Hey guys, so Murdaugh has been convicted and sentenced. Many think justice was done, but others think the trial was unfair and that as a matter of process, it should be reversed even if he did do it, or that he's actually innocent and would have been considered so if the trial had been handled differently. So let's look at how an appeal would work, because it's going to get an appeal here, and the likely grounds for appeal. Especially given Harpootlian's crowd-pleasing declaration they'd go to the Supreme Court of the United States. Yes, Justices Thomas and Sotomayor are standing by to join together to get Murdaugh out of jail as quickly as possible. Anyway, the real way an appeal happens, and Jim and Harpootlian did mention this in their press conference, it just didn't get the attention of the Supreme Court thing, is they first file a notice of appeal. That will come soon, as it should happen within 10 days of sentencing. Then they have to get a transcript. That will take from a couple to several months. Then they brief it to the court, where they tell the South Carolina Court of Appeals what they think the errors are. Once all that is finished, both sides finish a briefing and such, it goes to the court, it's fully submitted, there'll probably be an oral argument first, then a decision can come quickly, which is extremely unlikely, or it might take a year or so, which is much more likely. If you win, congratulations, you get a new trial. If you lose, you can ask the Court of Appeals to rehear it, and they might do it with all the judges or whatever, but probably not. You can also appeal to the South Carolina Supreme Court, and it's up to them if they take the case or not. Let's assume they don't take your case, or they do and they find against you. You are most likely then out of state options. You can ask the United States Supreme Court to hear your case. Notice the emphasis on ask. They have to actually agree to hear your appeal. You don't get to just do it. Cases they take are usually meant to provide broad application and guidance, like they're clarifying a law. Sometimes they're making law, even though they say they don't, or they're resolving a split in how the law is applied across the country. The acceptance rate of cases varies, but let's say it's roughly 2% on the criminal side. And that doesn't sound so good. You're fighting long odds, and you have to show them why you're not just butthurt about evidence rulings or how the jury came down, but this is some kind of case worth their limited time. Everyone who applies thinks that, obviously, so the odds that you're special are again about 2%. Then, if you did do it, you have to get the court to reverse, and that's unlikely as well. But if you do, congratulations, new trial. Another alternative is to go to federal district court, the lower federal court, right there in South Carolina. You can file what's called a habeas corpus petition, and that's based on the state violating your constitutional rights. So you're not just arguing a mistake at trial, but a mistake that removed the protections of a specific constitutional right. The Jensen case in Wisconsin was such a case like that, based on the letter from the grave of his wife who he murdered. You can file this petition, however, only after the state remedy is exhausted. So that means you got to go through all the state appeals first. And if you win, congratulations, new trial. If not, I suppose you could appeal to the Fourth Circuit Court of Appeals, but if you enjoy losing, it might just depend on how much stolen money he still has tucked away to afford all this. Well, that's the appeal process in a nutshell. What do you appeal? As I mentioned, you don't appeal based on butthurt the jury didn't do what you wanted it to do. It's in theory possible to appeal a verdict that, as a matter of law, it failed on evidence. But the general principle is that the appeals court does not set up there as a new jury just waiting to hear your case again. They're there to hear about legal errors in the case that rise to the level to be material enough to throw out a trial in its verdict. They don't sit up there and go, man, I kind of think that witness was telling the truth, man. They don't do that. They look for legal errors, and then they look for whether that's reversible or not, because there's no such thing as a perfect trial. So I'm sure the appeal will contain what are called assignments of error, or in the Darrell Brooks parlance, grounds. But let's look at 3 that have been talked about. There'll be others. I'm sure some of them could be good. I just haven't checked them out. The first is the admission into evidence of the financial crimes, or maybe just the amount of such evidence. It did sound like a lot to me, but not after I glanced at the over 300 pages of indictments chronicling just the cases they could figure out where he stole money. It was just a tiny sampling of that. But in the context of the murder trial, it sounded like a lot. Anyway, under Rule 404, the general idea is you can't admit evidence of prior bad acts just to show conformity. So in other words, you can't say, well, he was a bad guy who did these things, so he's probably the bad guy who did this thing. That's what the rule is meant to stop. You can, however, bring in evidence like that to show motive, a plan, or other things. I think the judge here did consider that as relevant to motive, and also what they call res gestae, or res gestae, or whatever. This case is full of like Alex, Murdaugh, whatever. Anyway, what that doctrine basically means is you can't know the full picture of how the crime unfolded without this information, so it should be allowed. But even if there is a permissible reason to bring this kind of evidence in, under Rule 403, it may be excluded if the probative value, in other words, the value of this towards the truth of the case, is outweighed by the danger of unfair prejudice. Now, obviously, all evidence that a side admits is intended to be prejudicial. That's the point of it. So this has to be unfair prejudice. And I think that word is probably going to be important in this case. So here you have the obstacle of convincing the appeals court that the trial court's ruling was legal error. And they generally view this with discretion toward the trial court. Like, they just don't sit there and go, well, I would have ruled differently, so by God, I'm going to reverse it. There's some discretion there for the trial court, or else why not have every trial up at the Court of Appeals where they're just perfect? So if a justice or judge would have personally decided differently at the Court of Appeals, that's not by itself a reason to overturn or to say it was legal error. You really, if there's discretion involved, it has to be unreasonable what the trial court did. And then the error has to be of such magnitude, depending on the type of error, that it had a material impact that the verdict should be thrown out, because some errors are harmless error. If you had 9 pieces of evidence about one thing and one more piece of evidence that maybe shouldn't have come in, they can look at that and go, well, it didn't really matter that he let this in because there were 9 other things establishing it. It wouldn't have changed anything. So frivolous, harmless error is not going to get the case reversed. Of course, anything can happen, but I wouldn't even bet Alex stolen money on this. Slightly more interesting to me will be the argument of the expert testifying in rebuttal about tossing the phone around to see if the screen lit up. He was on the stand as an expert under Rule 702, and I suppose he was, and I think the defense consented to this, an expert on what he testified to in the case in chief about cell phones. But in rebuttal, he testified about how unlikely it was that the screen would come on if you grabbed the phone and threw it out the window. That's something I didn't test in my shade tree video. But I get what he's saying. I did it at my desk, and if I grab the phone in a violent way and move it, the screen doesn't come on. But if I pick it up and turn it over, it does come on. So I see what he's saying. But his explanation of that was that any kind of scientific test, he just threw the phone around a lot over the weekend and reported it to the court. He didn't even make any records of how it went, how it did. So that's cool, but is it really the province of an expert? The defense objected here that while he was an expert to some degree on cell phones, he wasn't an expert on the physical dynamics of what causes them to turn on, and his experiment was not in any real way scientifically conducted. If the specialized knowledge of the expert is not beyond that of a normal person, then they shouldn't be allowed to offer opinions on things just like normal people can't on issues like that. So I think the defense argument here is good, that he was outside the scope of his expertise and had not established a basis to give his experiment credibility. But the counter side is that he was consented to be an expert on cell phones, and he knows why the screens sometimes turn on and sometimes don't, and he offered some practical testing and observations and reported based on his knowledge of cell phone operation. So while this might have been the loosest expert testimony in the case, it's not much different to me than testing shooter positions by holding dowel rods in the courtroom and tilting them back and forth and standing in the doorway of the courtroom, or having an engineer with no firearm expertise concluding that one wouldn't get into an awkward shooting position during a double murder. So the height had to be close to 5'4" or 5'2" or whatever. I guess what I'm saying here is the expert testimony has been fairly loose in this case. That's okay to some degree because the jury decides the weight of the expert. And if the expert is saying silly things, the jury is free to disregard them. So a lot of this expert evidence, in my opinion, on both sides was kind of eye-roll inducing to the declared certainty that they said versus the actual uncertainty that they were trying to divine. The difference between theory and reality is a lot greater in reality than it is in theory. But still, this is an argument on whether the expert, having passed the test of being an expert, was nevertheless allowed to testify improperly beyond his expertise. And the issue is material, as I think the idea the defense had is the phone may not have been thrown from a vehicle, but rather placed at its location, potentially by the tiny ninja. Now that's ridiculous to me, but I get the importance to the defense, particularly when the GPS data that came in mid-trial showed Murdaugh did not stop anywhere near where the phone was located. But come on, somebody threw that phone out a window. Let's keep it real here. Anyway, there was a South Carolina appellate case, Supreme Court, where a police officer testified as an expert based on evidence at the scene that a homicide victim was on his bike when he was shot, and that countered the defense claim that it was self-defense shooting. The defendant appealed and said the officer was not qualified as an expert on crime scene reconstruction, so his testimony was reversible error. He was qualified at the trial on crime scene processing. That's pretty close. The court agreed with the defense here that the expert testified outside his area of expertise and threw out the verdict. In the small State Department, Assistant Attorney General Creighton Waters was one of the attorneys appearing for the state. Now, that case isn't exactly on point. There are some material differences, but it touches the same issue here. Maybe it illuminates for you a little bit what the defense is trying to say. Murdaugh needs some state luck on these issues, because imagine thinking the federal courts are just waiting to step in on these evidence issues. That seems unlikely to me. Now, the third theory is something from the internet, which has been busy attacking the jurors. They didn't deliberate long enough. They're terrible people. I can think Murdaugh is innocent while knowing about his financial crimes due to my massive galaxy brain power. But once the jurors heard that evidence, they were powerless to consider him anything but guilty. The jurors engaged in misconduct. Yes, this last one, jury misconduct. Now, that's a problem, right? Has anybody got a copy of the motion filed by the defense on this? Anybody? Because I haven't seen it yet. And if you think you could just serve something like this up on appeal, not having raised it at the trial level, you probably have a social media law degree. And that's sad. Now, maybe they filed something, I haven't seen it yet, but right now it's just a lot of internet garbage. So I don't mean to make fun of only people who slander jury members because of the guilty verdict. I mean, a lot of these people think there was no case against Murdaugh at all. So you know you're dealing with some very limited reasoning power, either due to being dumb or overwhelmed by emotion or just rage commenting, whatever. If he had, though, been found not guilty, there would be galaxy brains on the other side claiming the fix was in. Swamp justice is no justice. The jurors are dumb. It's misconduct. The dozen eggs were actually a threat, whatever. Because when you lack the ability to see both sides of an issue, when something doesn't go your way, it has to be bad faith or rigged because of your flawless ability to preside over all things on the path of pure truth. If idiots were airplanes, internet comment sites would be the world's busiest airports. Now, as a practical matter, the appeal doesn't matter, as Murdaugh will be in jail forever for his long history of criminal activity, the scope of which certainly has not been fully revealed. I mean, this guy passed over $2.4 million, stolen dollars, to Cousin Eddie alone. Yeah, that Cousin Eddie, for purposes we don't really know yet fully. So nothing will restore his good name because he's a scumbag. Remember all the times he talked with Buster about how they needed to find the real killers and whether the family was still in danger and who would do this? I think it's zero. Maybe I missed one. Old Alec has a lot to be down about these days, but the fact he's still got enough razzle-dazzle to have internet people proclaiming his innocence is bound to bring a smile to his face at times. I mean, at least OJ kept up a pretense of searching for the real killers. But OJ knows what's up, and he said he thinks Alec did it. You can't kid a kidder, Alec. Thanks, bye.